I was asked today why I haven't covered the Andrew Bridgen, Matt Hancock story, and the blunt reality is that there hasn't been very much press coverage following whatever hearing took place, I think, on Thursday. So I would have expected the newspapers to be writing something on Friday. They haven't done so. So I think I ought to look very briefly at the background to this, because it seems remiss not to say something about it. Of course, one has to tread very carefully because it is sub judice, and but it's also unedifying. This legal battle between Andrew Bridgen and Matt Hancock. It's a case that Andrew Bridgen, of course, was associated with Lawrence Fox, and it's a case that, at best, is a procedural quagmire, and at worst is a lamentable misuse of judicial resources. And I think, in the end, it's about the extent to which parliamentary privilege covers what is said in and what is repeated out of the chamber. Biden's claim hinges not on Hancock's original statement in the Commons, which enjoyed parliamentary privilege, but on a tweet that followed it, where Hancock copied the either the Hansard statement or the video of the parliamentary session, and in the tweet accompanying that, Hancock condemned what he termed disgusting and dangerous anti-Semitic, anti-vax, anti-scientific conspiracy theories spouted by a sitting MP. Bridgen took umbrage, alleging that the tweet defamed him by implying that he himself was anti-Semitic, a charge he argues has seriously harmed his reputation. I think, however you look at the text that Hancock is quoting, I think it's very it's very unlikely that he was actually alleging that Bridgen himself was anti-Semitic. But this case is bogged down in fundamental ambiguity, and that's the problem. Hancock hasn't claimed the tweet is rooted in provable fact, nor has he presented any robust defence of the truth, a standard recourse in libel cases. Instead, he's relied upon the defence of honest opinion, asserting that his words merely reflected a subjective stance rather than the assertion of fact. And his argument, in essence, is that he was expressing outrage over the mode of Bridgen's expression rather than directly labelling him as anti-Semitic, a subtle but legally significant distinction. And from the court's perspective, the case is thin. High Court judges already claim that parts of Bridgen's claim are deficient, striking out certain aspects and ordering him to amend the arguments or risk the entire case being dismissed. And Bridgen has been ordered to pay £40,000 in to Hancock's legal fees, a clear indication of the court's view that his claim, as it currently stands, is not particularly compelling. Hancock, for his part, has maintained a dismissive stance, calling the lawsuit absurd and urging Bridgen to drop it. I would follow Hancock's advice there. The former health secretary, whose own political career ended in disgrace following his COVID rule-breaking scandal and his clinch against a wall, which I much prefer to think took place in a stationery cupboard. Oh, let's make this stationery cupboard move! Appears to be he appears to be relishing his courtroom victories, however procedural they may be and however slight. But the bottom line is they're both wasting valuable time at a point when the backlog of legal cases is significant. Bridgen, however, insists that Hancock's words caused him grievous harm, particularly in the wake of his expulsion from the Conservative Party, his subsequent failed re-election bid, and his legal team argues that accusations of anti-Semitism are ruinous for a politician and that Hancock cannot simply evade responsibility by couching his words in opinion. I think there's many other things that have been ruinous for Bridgen's parliamentary career, and many of them he's brought on himself. I'm not suggesting that Hancock's statements were wise, and I'm not suggesting that Hancock is entirely blameless. I would hardly suggest that Hancock is blameless. Hancock is the person who was fiddling around in the stationery cupboard, looking for an HB pencil with a rubber on it, and he affords me endless hours of fun by thinking of Frankie Howerd and Kenneth Williams locked in a tight embrace against the photocopier. But regardless of the of the issue, Bridgen insists that Hancock's words have been injurious, and his legal team argues that they are that the anti-Semitic charge is ruinous. But one cannot escape the sense that this case is little more than an exercise in legal brinkmanship, and the courts, with their significant backlogs, are being asked to adjudicate a dispute that, in a saner world, could have been resolved with a retraction, an apology, or perhaps acceptance that in the raucous realm of politics insults are part of the terrain. Ultimately, both men could do well to consider whether their time and the court's time might be better spent elsewhere. Hancock I think both Hancock and Bridgen's careers are both over, and Hancock is likely to emerge perhaps less hurt by this than Bridgen. He might even emerge relatively unscathed. Bridgen risks further financial and reputational damage should this case collapse entirely, because he's pinned so many hopes on a judgment. This is a legal duel between two figures whose political relevance has waned. Yet their determination to slug it out in the courts only underscores their lingering appetite for the limelight. In the grand scheme of things, one might argue that neither emerges as a victor. Instead, it's the judiciary that must bear the burden of this protracted and frankly avoidable dispute, and only the legal boffins. And the legal boffins are the only people who are going to benefit from this.